foremost, we are not the maker of the documents. And we were not there when he made the documents. We cannot speak appropriately about the documents that our clients did not make. Since we don't have knowledge, or we didn't make the documents. The one who made the documents, who have denied it, possibly in the court of law, wherever, he would appropriately tell the court whether he made the document or not. As a matter of fact, distinguished chairman and the distinguished committee, we have filed a matter in the High Court in respect of this. And we have that process forwarded with a letter to your distinguished committee. Apart from that, we've also filed an originating summons accompanied with a motion notice at the Federal High Court challenging the powers of the committee to look into matters like this as is provided in the Constitution. So, this matter is already sub judice because it's before the courts.
We take judicial note, or we take a note of your submission. We know our rights under section 89, 88, 89 of the Constitution, 89 of the Constitution. We know our rights. There are procedures for exercising those, rights. We know our rights under Legislative Powers and Privileges Act. We know our rights. Don't educate us on that one. But on his honor, like I said, the papers you brought, that summon has no effect on hearing this case before Nigerians. Because it's an afterthought. An attempt to ambush justice. So on his honor, this committee will rule. In another 2 weeks, you will communicate this day to Justice Umar. Danadi Umar must be physically present to come and address this issue before Nigerians. On his honor. On his honor. So then when all these things are utilized, and then we now go to other sections of section 80 to 89, issue warrant of arrest, we exercise patience because we are representing all of you. But on his honor. And the fact that this committee is the one even supervising him, supervising that agency, he must also give this committee a honor. You cannot ask us not to do our work. We are democratically elected here. So bringing court someone is an afterthought. It will not be accepted by this particular committee. It will not.
Distinguished committee, I don't know if I can
Did I ask you to speak? I didn't ask you to talk.
permission to speak, sir.
No. I don't get no permission to speak for now. You said you came with two summons. Submit the summon. It's void ab initio because there was this particular this case was not in court ab initio. If it were to be in court, the second day we will dismiss it and say they should go to court. And then if this one is fabricated, we know who is the owner. We will ask MTN to give us the owner of this particular phone that answered that case. We will go and bring him and arrest him. Because the owner of this phone answered my call. Incidentally, this committee supervises Code of Conduct Tribunal. By virtue of the standing order of the Senate, this committee supervises, oversees the activity of Code of Conduct Tribunal. In the first time, we have a right to summon the chairman of that tribunal to come and answer any cases before this committee. Apart from that, this committee is a special committee of the Senate. And any case before it, we have right to hear it. But if the case are going to court, before coming here, it's sub judice. National Assembly is an independent arm of government. The function of the executive, we cannot perform the function of executive. The executive cannot perform our own function. That is why, if a case goes to the judiciary arm of government, another independent arm of government, before that complaint is laid before the court of the people, we say it's sub judice. It has been taken care of. Let the court go and judge that case. Not when the case is before National Assembly. Before we now call you to come and respond. You now quickly run to court to go and stop the court, stop National Assembly from hearing it. Even the Chief Justice will hear from this one that it's wrong. A case is before us already. We have had the respondent. We have had the petitioner. We now ask the respondent, come and tell us your own side. You use sickness. First, second time, third time, the fourth time now, you come with court summons that we can no longer hear the case. Okay? And I'm not a lawyer, but I know the rule of the game. The question is that your man will still come and tell us. Even if we are going to draw the case for court to hear it later, we must hear his own side. There are different issues now. This boy says he's not the one that wrote, but I called him, he confessed to me that his father has to go and withdraw. Now, he's now telling the whole Nigeria that he has not withdrawn. And now you say you are coming with originating someone now to stop this committee from hearing this case. Even the president will hear about this one, though. Where you use justice to stop the National Assembly from doing his own work. So, sir, I think you can. You are a lawyer. You are the chairman of the judiciary.
Well,